Welcome to Legal Lines. My name is Tom O'Shea, the host of this program brought to you by the York County Bar Foundation. My guest today is attorney MacGregor Brillhart, an attorney with Stock and Leader, and our topic is estate planning and Medicaid planning. So welcome, Mac.
Thank you, Tom.
And let's start on the first topic, estate planning. And in general, what does that cover?
Estate planning generally covers the disposition of someone's assets upon their death, so planning where your real estate, your cash, your personal property would pass upon your death, as well as planning for who would take care of your financial assets and healthcare decisions if you become incapacitated but are still alive.
So we're not only dealing with the possibility, the inevitability of death, but we're also dealing with the possibility of someone being incapacitated prior to death where somebody has to control their assets.
Exactly. We find oftentimes when clients come in, they primarily ask for a will to be prepared, but oftentimes a power of attorney, the lifetime document, is equally as important in that the person is able to plan for who would take care of their assets and make, for instance, mortgage payments, tax payments, things like that while they're still alive but unable to do so.
Right. Let's talk about the power of attorney because you just stated how important that document is. What exactly is a power of attorney?
A power of attorney is a legal document where the person that signs the power of attorney, the principal, names an agent to act for them if they're either unavailable or incapacitated. And within the power of attorney, you would name your agent, and most times in the event that your agent is not available, you would name a successor agent, a person to take over for that primary agent.
So if somebody was, let's say, incapacitated, they were in a coma, and if they had someone with a power of attorney, that person could do their banking for them?
Correct.
That person could transfer assets, pay their bills, and do basically anything financially that the incapacitated person could do.
Right. What we try to do is include, depending on what the principal wants, any and all financial powers that the principal himself or herself would have if they were acting on their own. And so there's a laundry list, a long list of financial powers related to insurance, taxes, banking, things of that nature that the agent, when acting for the principal, is limited to the powers that are in the power of attorney.
So you could have a power of attorney that deals with only certain aspects, like maybe a checking account, or you could have a more general power of attorney that deals with basically everything. Exactly.
It's the powers that you include in it. Another important point to make is that there are different types of powers of attorney. For instance, there's a durable power of attorney, which when signed is active, which means that the power of attorney is in play even if the person's not incapacitated. So for instance, if someone was out of state or out of the country but not incapacitated, the agent could step in and make financial decisions for the person. Whereas a springing power of attorney is a power of attorney that essentially springs to life when the principal is incapacitated.
Okay. And one of the other things I think is important that I remember, and I don't do much estate planning work, that the power of attorney terminates upon death. Is that correct?
That's correct, Tom. So the fiduciary, what we call the agent, his fiduciary duties and his authority to act or her authority to act ceases upon the death of the principal.
And that's basically if somebody has the will, that's when the will would take over. But before I talk about wills, I want to talk about the power of attorney. What happens if someone becomes incapacitated and they do not have a power of attorney?
Right. This is something we see frequently, unfortunately. A power of attorney is a fairly simple document to prepare, but unfortunately we come into circumstances where a person is already incapacitated and there's not a power of attorney in play, and financial or medical decisions need to be made for the principal. In that extent, we would seek a guardianship through the court, and the guardianship is the legal process where a petition is filed with the Orphans Court in York County, and a proposed petitioner asked to become the guardian of that incapacitated person's estate and person.
So by doing a little planning and having a power of attorney, you avoid, number one, a court hearing, where you have to go to court and ask a judge to appoint someone to take care of the financial matters concerning the incapacitated person. Number two, you can direct who you want to be your power of attorney instead of leaving it up to the court.
Exactly.
Okay, and number three, the power of attorney can act right away instead of waiting for a court to schedule a hearing and rule on it.
Exactly. Those are the reasons a power of attorney is preferred. And again, power of attorney, simply put, cheaper than a guardianship proceeding, and also, as you touched upon, the ability to name who it is you would want to act, whereas when you're incapacitated, whoever petitions the court is essentially nominating him or herself as your guardian.
Okay. Now, the next document is the will, and that's what most people think of when they think of estate planning. And the will is the document that basically states what's going to happen to your assets when you die.
Right. One important distinction to make is that not all of your assets are actually distributed under your will. Certain assets we would call non-probate assets, and those assets do not come under the terms of the will. So to start, the assets that do not come under the terms of the will would be assets that are either titled jointly or have beneficiaries on them. Those assets would pass to the joint surviving owner, or alternatively, the beneficiary that's designated on the asset.
So if I had a will that said I leave everything to my one child, and I had an insurance policy that said my other child is the sole beneficiary, the insurance policy would never be part of the probate estate.
Exactly. And we've seen circumstances, for instance, where there's two children, and under the will, mom and dad leave everything equally to son and daughter. But for whatever reason, a life insurance policy or an IRA or a 401k would have only one child, perhaps by mistake, and that money under that beneficiary designation passes to that one child, which may or may not be what the principal wanted, which oftentimes leads us to part of estate planning is not just preparing a will, but ensuring that beneficiary designations are current and up to date.
Okay, and also with the joint assets, sometimes you can avoid the expense of probate. For example, in many cases, a husband and wife would own a house together. When one dies, the spouse automatically owns the house without going through probate.
That's correct. Titling assets jointly is a way to avoid probate, but I would say that there's a lot of misconception out there about avoiding probate. And probate in Pennsylvania, and specifically in York County, is not an overly expensive process. It's essentially $100 per $100,000. And so I feel that there's a lot of fear-mongering that goes on. Probate is the process in which there's court oversight and supervision to ensure that the dictates of the will and estate plan is followed. But you're correct in the fact that titling things jointly does avoid probate.
Okay. Now, sometimes we hear the term a trust being part of the estate plan. Exactly what is a trust?
A trust is a legal, its own legal entity that can own something. So whereupon you or I can own our house individually or with another person, an asset can be placed into trust, and the trust would then own that asset. Trust can be, there's different types of trust. There can be a trust under will, we would call it testamentary trust. There can be a living trust that's created when someone's still alive. And again, the idea is to take the ownership of an asset and put it into a trust.
And so someone called the trustee would be the owner of the asset, the legal owner, but the beneficiary gets the benefit of what's ever in the trust.
Right. The trustee would be in charge of managing the asset according to the terms of the trust.
Right. And you can name a person to be the trustee, or you can name a financial institution. Is that correct?
Correct.
So many banks have a trust department where they will act as the trustee because basically they're in the business of doing that and they know how to do it correctly, and they would invest the assets correct.
Absolutely.
Okay.
And we see we often see trust used, for instance, if you have children that are at a younger age and you have a contingency in your will that upon the death of both spouses, assets would pass to children. It might be that children at an age of 15 or even 20, 25 are not prepared to inherit the assets, and so the trust would own those assets, and the trustee will distribute the assets according to the terms and times set forth in the trust.
Okay. Another document that we sometimes hear about is a living will. And what is a living will?
A living will is a document that describes the end-of-life care you wish to receive. So it's specifically limited to times when you are permanently unconscious or terminally ill. And in the example that you're terminally ill or permanently unconscious, you can dictate whether you would like to receive medical care or, as we put it, let nature take its course.
Okay. Do you appoint someone to make those decisions for you in the living will?
Good question. You do not have to, but you can. There's a place in a living will where you can nominate a surrogate. Some people believe that the purpose of a living will is for you to set forth your wishes at end of life, and that placing a burden on another individual is unfair. And so there's a box you can check on a living will that essentially says, I do not name a surrogate, my wishes have been set forth above, and this is what I want to happen. Alternatively, you may want to name a surrogate for whatever reason you would like. For instance, you may want a second opinion before you're taken off a ventilator, for example. So you have the ability to name or not name a surrogate on a living will.
And here again, what happens if somebody does not have a living will? How are these decisions made?
There's a fallback provision, and we spoke previously about a power of attorney financially. Likewise, there's a healthcare power of attorney where you can name an individual to make healthcare decisions for you. There is a fallback statute in Pennsylvania that names a healthcare representative. So in the event that you do not have a healthcare power of attorney or a living will, you can essentially name, the statute names someone in order of next of kin that would make those decisions for you.
So by having a living will, you're basically taking the burden away from your next of kin, who probably will not be in an emotional state where they will want to make those decisions.
That's one way to think of it.
Okay. And one of the other things that we need to touch on with estate planning is taxes. There's something called death taxes.
Right. There's essentially two types of death taxes in the United States. One is a federal estate tax, and that currently is limited to estates in excess of $5 million. Now, this law is in flux right now, depending on whether Congress extends it, passes a new law. But if you die in 2012 with less than $5 million, you're not subject to a federal estate tax. However, if Congress does not act before the end of 2012, the law will revert back to $1 million, and anyone with an estate in excess of $1 million would be subject to federal estate tax.
Now, they extended that law prior years, correct?
They did.
And that's the one where they say throw grandma in front of the bus on New Year's Eve or something like that, so that she would you wouldn't have to pay the tax if she's a wealthy old lady. You would. There was a
law in the tax in which there was actually no estate tax at all. George Steinbrenner died when there was no federal estate tax.
Lucky George, right? But at any rate, the estate tax is on the estate itself, and then there's also an inheritance tax which exists in Pennsylvania.
Right. We have a Commonwealth inheritance tax here in Pennsylvania, and that death tax does not have a threshold. So essentially, every dollar that you die with in Pennsylvania is taxed at a certain rate.
And is that rate depending on the relationship of the beneficiary to the decedent?
Exactly. So for instance, between spouses, there's no Pennsylvania inheritance tax due. So when one spouse dies and leaves everything to the other spouse, no tax due. Children, lineal descendants, 4.5%. Siblings, 12%. And all other parties, 15%.
Okay, so that's how much the tax would be to the state. And the federal government right now only exists if there's more than $5 million in the estate. And we're out of time on our first segment. We'll be back after a brief intermission, and thank you. Welcome back to Legal Lines. My name is Tom O'Shea, the host of this program brought to you by the York County Bar Foundation. My guest is attorney Mac Brillhart, an attorney with Stock and Leader. We're talking about estate planning as well as Medicaid planning. And we'll get to Medicaid planning in a minute. But first, right before the break, we were talking about the Pennsylvania inheritance tax. And during our intermission, you indicated that there was that life insurance is not subject to the inheritance tax. Is that correct?
I had stated that every dollar essentially in your estate is subject to Pennsylvania inheritance tax, which is not entirely correct there. Life insurance is not subject to Pennsylvania inheritance tax, nor are retirement benefits when the decedent has died before the age of 59 and a half, just for clarification.
So if I have a life insurance policy that says my children are to receive the benefit, the death benefit upon my death, none of that gets taxed.
It's not subject to Pennsylvania inheritance tax. It is subject to federal estate tax if you fall within that
if you're
amount.
above that $5 million amount that most of us are not.
Like Tom O'Shea.
Okay, well, there we go. But we also said the program would deal with Medicaid planning. Now, what is Medicaid planning?
Medicaid planning is the process of planning for an individual transitioning into a nursing home. Medicaid is a federal state benefit that's paid, that essentially covers an individual's skilled nursing care when they've reached a certain threshold as to their assets. It's a poverty program.
Okay. So why would there need to be planning for people to basically go into poverty?
Well, the idea would be that there are certain exemptions under the law and transfers, assets that are exempt from spending down to the point that you apply for Medicaid.
Okay, well, if I could give an example. Let's say we have a husband and a wife who've been married for a very long time, and they're up in years, and one of them is having serious health problems. There may come a time where that individual might need to go into some type of nursing care. And if they own a house together, will the wife have to sell the house if the husband has to go into the nursing care facility?
No, one of the exemptions under the law is that a primary residence is exempted from nursing home spend down. And the term I use, spend down, is if we have the threshold amount, which is tied to the individual's income. Say, for instance, the threshold amount is $2,400. We would take the marital pot of money and essentially split it in half. It gets a little more technical than that, but split it in half, and the spouse that's in the nursing home has to spend down his or her share to that threshold amount. Certain things, however, are not in the marital pot and they're exempt. One of those things is a primary residence. So, for instance, if wife remained in the home, that does not count towards the process of applying for nursing home benefits.
Okay, so part of this Medicaid planning and it is outside of just the house, but other assets, so that the other spouse, the spouse who doesn't need the nursing care right away, would be able to keep some assets to support him or herself, as while the other person qualifies earlier for Medicaid benefits to pay for the nursing care. Is that
that's
basically
one way to put it. Protecting assets for not only the spouse, but an eventual inheritance for the other family members. One of the things we would do essentially is when we have the finite number that needs to be spent down by the spouse in the nursing home, there are again certain allowances that the money can be spent on as opposed to just paying the nursing home every month. And examples of this would be prepaying one's funeral or burial. Rather than simply paying $8,000-9,000 a month to the nursing home, you can prepay your funeral. You can make repairs to the home. You can purchase a vehicle if you don't have a vehicle. So there are agreed upon expenditures that are permitted, and those are things that people are sometimes unaware of and seek an elder law attorney to assist with.
Okay, so for example, when you're saying funeral expenses, if someone did not make pre-existing arrangements for a funeral and they spent down their assets before Medicaid took over, there might be no money left for the funeral expense.
It's possible. And then, essentially someone would be responsible for that. Not responsible for that, but someone would be expected to step forward and make the payment to arrange for that after death.
Now, sometimes what you'll hear people say is, can I give my assets away so that I can avoid it going to the nursing home, or so I can avoid the death taxes? And what's the answer to that?
That's a question we get a lot. So for Medicaid planning purposes, you can imagine that the government is not too keen upon you simply giving away your assets so that you can get on medical assistance. And so the rule as it stands right now is that there is a 5-year look back from the time an individual applies for Medicaid. So if you've made a gift, whether it be transferring the title of your home to your son or you've gifted cash to someone, those assets and the transfer of them as gifts need to be disclosed and can end up disqualifying you from benefits regarding a computation that's used to determine the length of time.
Okay. So basically, like with everything else, you can plan your estate taking into consideration the possibility that you might need nursing care in the future, and work it out so that basically, if I'm hearing you correctly, that Medicaid pays more of your nursing care bill than your children do. Is that
That's a fair statement.
That's a fair way to look at it. I want to touch on something else that's a good program that I know that you're the chair of, and that's called Wills for Heroes. Now, can you tell us about that program?
Sure. Wills for Heroes was created back after September 11th in 2001. There were a number of first responders, whether they be emergency responders, police officers, firefighters, that responded to that tragedy, and upon dying during that tragedy, it was realized that many of them did not have an estate plan in place. And after thinking about the fact of what many of these men and women do and what their daily tasks are, it's important that they have an estate plan in place. So the Pennsylvania Bar Association adopted this Wills for Heroes program, and York County adopted it 2 years ago. The program is designed to provide free estate plans for police officers, firefighters, emergency personnel, and their spouses.
Okay, so how would a first responder, let's say a firefighter, qualify to have a free will?
What we do, essentially at this point, we're having 2 events per year. One is generally in January or February, and another we try to have occur right around September 11th, so in September. And we have those events at Penn State York, and we have a rotating invitation to different municipalities, boroughs, and we reach out to them and give their firefighters, police officers an invitation to come over to Penn State York that day and with their spouse and have wills, powers of attorney, living wills prepared.
Okay, so I take it that all the attorneys who are involved in this program are volunteering?
Exactly.
And in addition to the attorneys volunteering, does anyone else participate?
We actually have paralegals from the Paralegal Society of York come, and so we have a notary station set up and a witness station, and we have an attorney and a paralegal meet with the emergency response person and their spouse, talk to them about their wishes, and then prepare the documents and transition them over to the paralegals who then execute and notarize and witness the documents.
So basically, someone who qualifies for this program would be able to have every document completed that day?
That's correct.
And does the document, let's say that a firefighter wants to have a will, is his spouse eligible to get a will at the same time?
Absolutely. We invite both the personnel and their spouse.
And it's typical, is it not, that spouses would write wills at the same time to cover whichever one might die first?
It's very typical.
So volunteer attorneys working, through the York County Bar Association?
Yeah, the program is sponsored through the Pennsylvania Bar Association. This is a long explanation, in conjunction with the Young Lawyers of York and the York County Paralegal Association.
Okay, and there is a Young Lawyers Division, which I'm no longer eligible to be in for quite a few years by now, but I know that you're still in the Young Lawyers Division, and so it's mainly the younger lawyers who are taking part in this program.
It is. We have a number of young lawyers that assist. However, we do have a handful of older estate planning practitioners that we call experts. And essentially, as the documents are prepared by the younger attorney, we have the estate planning expert review the documents before they're signed.
Okay. And this program, it would be at Penn State York. Times are announced well in advance.
Yeah, we publicize everything through the newspaper, and we make a direct invitation to the different boroughs and municipalities we invite on a rotating basis.
Well, so let's say you invite York City, for example, at this one occasion. Can somebody from another borough come at the same, even though they're not part of the invitation that time?
We try to limit that because depending on how many people we have volunteering and how many hours we're doing it, if we leave it open to the whole county, we clearly wouldn't be able to assist everyone that day. So we would ask that invitations are waited for by each different department until we invite them. But we are trying to get to each department.
Okay. And so if I'm eligible to participate, what should I know before I come?
Right.
What should I anticipate? Should I plan out who for example, the executor of my estate would be, how I want my assets to be divided. These are the types of things people need to know before they show up.
Exactly. The program is very well administered. So when you sign up, you're given a specific time slot. You're given what we call a client information statement, in which you name your children, you name your grandchildren, and they ask you very pointed questions about where you want specific assets to go, contingencies if that person predeceases you, who you would want to control your estate as your personal representative. It's a lengthy questionnaire that would ask you all the questions you need to know to prepare for the meeting.
Okay, and then about how many people participate in any given program?
We usually have about 30 to 40 volunteers there, whether it be paralegals or attorneys, and we service anywhere between 40 and 65 emergency personnel that day.
Okay, and it's a wonderful program, and it's very, very nice to be done. And I assume you have the notaries there as well to take care of notarizing the documents. And in addition to the wills, do you do the powers of attorney and living wills at the same time?
We do. They leave with notarized and witnessed wills, powers of attorney, both financial and healthcare, as well as a living will.
All right, we only have a few seconds remaining, and what I'd like to also mention is a program called Leave a Legacy. I know that's something that was sponsored originally by the York County Bar Foundation, and could you tell us just briefly what that program is?
Sure. Leave a Legacy is a program that's designed to encourage individuals that have a charitable intent to name that charitable organization in their will.
Okay, and basically when you're writing your will, most people think of, I'll leave these assets to my spouse, to my children, but when you leave assets to charity, you're basically leaving your legacy, like the title says, plus those assets are not subject to any tax.
That's correct.
That's correct. And we're out of time. So thank you, Mac. This is Legal Lines. My guest was Mac Brillhart. Thank you.